Good day, madam. I'm Vimanahini Pragas. We are from Group 1 and today we are presenting question 2. So I'll start off with introduction. Non-conventional trademarks such as sound, colors and shape go beyond traditional logos and words. This presentation compares how the United States and the European Union recognize and register this trademark and how their legal system manage the challenges involved. Now, I'll be explain the recognition of non-conventional trademark. So in United States, non-conventional trademark are widely recognized under the Lanham Act. The law allows protection for any signs that can identify the sources of goods or service. As a result, the US accepts sound marks, color marks, and trade dress. For example, in the case of Qualitex and Jacobson, the court confirmed that a single color can be a trademark if it identifies the brand and it's not functional. The key focus is the US is whether the consumer linked the sign to one business. In comparison, in the European Union, was traditionally more restrictive. Earlier, EU law required trademarks to capable of graphic representation, which made it difficult to protect non-visual marks like smell. This shown in the Sigmund case where a scent mark was rejected for being unclear and imprecise. However, this changed in 2017 when the EU removed the graphic representation requirement. And today, non-conventional marks are recognized if they can clearly distinguish goods and be represented using technology such as sound file and or video formats. Next, the registration of non-conventional trademark. So in the United States, registration depends heavily on distinctiveness. Most of non-conventional marks are not inherently distinctive and must show secondary meaning. This means owner must prove that the consumer associate the marks with the single source. Evidence such as long-term use, advertising, and consumer services are often required. The US also applies the functionality of doctrine, which prevents registration if the feature is useful or give a competitive advantage. In the European Union, registration standards are way stricter. Even though the digital files are now accepted, the trademarks still be clear, precise, and objective. Sound and motion marks are commonly registered, but the scent and taste marks remain very difficult to protect. The EU also carefully prevent monopolization by refusing marks that are necessary for the product nature or that add substantial value. This difference show how legal systems balance brand protection with the fair competition, offering useful lessons for countries like Malaysia. That's all from me. I pass the floor to the next person.
Now, I will talk about the enforcement of non-conventional trademarks in the United States and also the European Union. So in the United States, non-conventional trademarks such as sounds, colors, and trade dress are enforced under the Lanham Act once validly registered or proven through use. So courts protect these marks against infringement if there is a likelihood of consumer confusion, and enforcement is strong provided the mark functions as a source identifier. So famous examples include sounds and color marks that have acquired distinctiveness through extensive use. In the European Union, on the other hand, enforcement is governed by the EU Trademark Regulation, EU TMR. So once registered, non-conventional trademarks enjoy the same enforcement rights as traditional marks. So right holders may prevent unauthorized use that causes confusion or takes unfair advantage of the mark's reputation, subject to strict compliance with the registrability requirements. Now I'll talk about the challenges in establishing the distinctiveness in the US and also the European Union. So in the US, the main challenge is proving acquired distinctiveness. So non-conventional marks are rarely inherently distinctive. So applicants must show that the consumers associate the mark with a single commercial source. So evidence includes long and exclusive use, advertising expenditure, consumer surveys, and market recognition. So while the US system is flexible, the evidentiary burden can be high. Meanwhile, in the European Union, the challenge is even stricter. So applicants must prove the mark is distinctive across the entire European Union, not just in one member state. So the Court of Justice has consistently held that mere originality or aesthetic appeal is insufficient. Evidence must show that the relevant public perceives the sign as an indicator of origin, making registration of non-conventional marks more difficult than in the US. Finally, comparing it to Malaysia, the US adopts a more flexible, evidence-based approach, while the European Union applies a stricter and more uniform standard for distinctiveness. In Malaysia, under the Trademarks Act 2019, non-conventional marks are recognized in principle, but applicants similarly face difficulties in proving distinctiveness. So Malaysia can learn from the US by allowing a broader evidentiary methods while adopting the European Union's caution to prevent overboard monopolies.
Thank you. Besides, the second key challenge is the risk of monopolizing common or functional product features, which could result in distorting market competition. This concern is particularly evident in the legal approaches of the United States and the European Union. This is because both of these countries have developed robust mechanisms to prevent trademark law from being used to create patent-like monopolies. Firstly, we'll look into the United States. In US, the functionality doctrine is the main safeguard against monopolization. As an illustration, the landmark case Traffic Devices Incorporated and Marketing Displays Incorporated illustrates this principle, whereby the US Supreme Court ruled that a jewel spring designed for road signs could not receive trade dress protection because it was functional, and granting exclusive rights would harm competition. The court also stressed that such protection would place competitors at an unfair disadvantage. A similar approach was taken in the case of Qualitex Company and Jacobson Products Company. While the Supreme Court accepted that a color could function as a trademark under the Lanham Act, it was made clear that the protection must be refused where the color serves a functional purpose. This is because it would effectively create a monopoly over basic commercial features rather than protect brand identity. Hence, it is clear that the Lanham Act of the United States prohibits a product feature to be protected as a trademark if it is essential to the product's use or affects its cost or quality. On the other hand, the European Union adopts a more proactive and codified approach. For instance, under Article 71E of the European Union Trademark Regulation, it states that the signs consisting exclusively of shapes or other characteristics resulting from the nature of the goods necessary to obtain a technical result or giving substantial value to the goods are absolutely barred from registration. Additionally, in the case of Phillips and Remington, the Court of Justice refused the registration of a three-headed shaver shape, holding that trademark law must not be used to perpetuate monopolies over functional product designs. It is clear that the European laws has reflected a strong public interest in preserving the public domain and at the same time preventing the traders from monopolizing features that the competitors may legitimately need. It is clear that both the US and EU share a common objective, which is ensuring trademark protection does not undermine competition. However, their methods differ. While the US relies on judicial development of the functionality doctrine, the EU embeds anti-monopolization principles directly into statutory refusal grounds and administrative practice. In Malaysia, Trademarks Act 2019, particularly Section 28, mirrors these approaches by excluding shapes and features that are functional or give substantial value to goods. However, Malaysia lacks detailed examination guidelines and a substantial body of judicial interpretation comparable to the US and EU. That's all from me. Now I'll pass the floor to the next person.
My part focuses on one key challenge, which is addressing cultural and sensory considerations. Non-conventional trademarks such as smell, color, or sound rely heavily on human perception. What is distinctive or memorable in one culture may be ordinary or meaningless in another. This makes recognition, registration, and enforcement particularly difficult. In the United States, under the Lanham Act, particularly Section 1 of Lanham Act, where it allows registration of trademarks used in commerce, Section 2F of Lanham Act permits registration based on acquired distinctiveness, and Section 45 of Lanham Act defines trademarks broadly, including any symbol or device that identifies source. So non-conventional marks such as color and scent may be registered if they identify the source of goods and have acquired distinctiveness. In Qualitex and Jacobson Products, the Supreme Court held that a single color could function as a trademark if consumers associate it with a particular source. Cultural meaning was not decisive, instead the focus was on actual consumer perception. Similarly, in the case of Ree Clark, a scent mark was accepted because consumers did not normally expect sewing thread to have a fragrance. In contrast, the European Union adopts a much stricter approach. Under the EU trademark regulation, sign must be clearly and precisely represented. In Ralph Siegman and Duchess patent, a smell mark was rejected because it could not be graphically represented in a clear, objective, and durable manner. The court prioritized legal certainty over cultural or sensory experience. Likewise, in Libertel and Benelux case, A single color was only acceptable if defined using an objective system such as a Pantone code. Cultural interpretation of color was considered subjective. I will now compare the approaches of the United States and the European Union towards non-conventional trademarks. First, in terms of flexibility, the United States approached a more accommodating approach. The focus is on consumer perception. If consumers recognize a sensory feature as identifying the source of goods, it may be protected as a trademark. In contrast, the European Union takes a much stricter position. Sensory marks must be clear, precisely, and objectively represented. Because sensory experience like smell are difficult to represent in an objective and durable manner, many non-visual marks are excluded from registration. Second, regarding cultural consideration, the US considers culture indirectly through consumer perception. The EU, however, largely ignores cultural interpretation as it views cultural and sensory meanings as too subjective and inconsistent to provide legal certainty. Finally, in terms of risk, the US approach may lead to subjectivity and monopolization. The EU approach avoids this by prioritizing legal certainty, but this comes at the cost of excluding non-visual marks even when they may be distinctive in the marketplace. When we compare both systems, the US is more accommodating to sensory and cultural diversity but risks subjectivity and monopolization. The EU ensures certainty but excludes many non-visual marks. Malaysia, under the Trademarks Act 2019, particularly Section 2 and 3, largely follows the EU approach, including reliance on the segment criteria. Given Malaysia's multicultural society, a possible reform would be to allow greater evidential flexibility, such as consumer surveys, while still maintaining safeguards to prevent monopolizing culturally common sensory features.
Hi madam, I'm Yolashin. Now I'll be focusing on reforms and recommendations for Malaysia by using the United States and the European Union as reference model for improving the regulation of non-conventional trademarks. Firstly, Malaysia should reform its approach by adopting the US evidence-based system. In the US, non-conventional trademarks such as colors, sounds, and product appearance are only protected when the owner can prove acquired distinctiveness through real market evidence, including long-term use, advertising, and consumer recognition. Malaysia can strengthen its system by placing greater emphasis on actual consumer perception, rather than relying mainly on abstract distinctiveness. At the same time, Malaysia should reinforce the functionality doctrine following the US model to prevent businesses from using trademark law to monopolize functional or essential product features. These reforms would help safeguard competition and innovation. Besides, Malaysia can further reform its examination process by adopting the European Union stricter standards. The EU applies a high threshold for distinctiveness and carefully considers public interest when assessing non-conventional trademarks. By applying similar scrutiny, Malaysia can prevent the registration of marks that may give applicants an unfair competitive advantage. Overall, these reforms would help Malaysia strike a better balance between brand protection and fair competition. In conclusion, Malaysia should reform its non-conventional trademark framework by combining the flexibility and market-based approach of the US with the strong competition safeguards of the EU. This would create a clearer, fairer, and more effective trademark system. So that's all from our group. Thank you.